I don't like this. We'll get started in 1 minute, hopefully. Good morning and welcome to the September 10th, 2025 meeting of the Texas Commission on Environmental Quality. It is 9:39 a.m. I'm joined by my colleagues, Katarina Gonzalez and Bobby Janeka, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument and discussion is allowed, we will inform the parties and public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit our registration table if you're here in person, or if you're on the webinar, email agenda@tcq.texas.gov with your name, affiliation, and the item you'd like to comment on. We will do our very best to accommodate the requests. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking, and please check to make sure that your line is unmuted before proceeding. All right, Mary, call the first item.
Item number 1 is the consideration of whether to affirm, modify, or set aside the emergency order appointing a temporary manager for the public water system owned by David Gillott, Lanai Gillott, and operated by Seng Phet Souimaniphanh. The ED will speak first, followed by the public water system owners or operators. If here, currently they're not signed in. Any interested persons, and again, we don't have anyone signed in that asked to address the commission. Aqua Texas, the temporary manager, again, not present. And then OPIC. Each party will be limited to 5 minutes for their presentation, and the ED may reserve time for rebuttal as the ED bears the burden of proof on this matter. So we'll begin with the executive director.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Ben Worms, and I'm an attorney with the Litigation Division representing the Executive Director. With me today is Kristen Hernandez with the Water Supply Division, and we're joined online by Crystal Watkins of the Dallas-Fort Worth Regional Office. Item number 1 concerns an emergency order renewing the appointment of a temporary manager of a utility owned by David Gillott, Lanai Gillott, and previously operated by Seng Phet Souimaniphanh. David Gillott and Lanai Gillott own the real property that the utility facilities are located on, and Seng Phet Souimaniphanh, doing business as TL Water Jones Acres, maintained operational control of the utility from at least February 2017 to the issuance of the first emergency order in 2024. From 2018 to the issuance of the first emergency order, 10 complaints were made to TCEQ about issues at the utility, alleging persistent low water pressure, water outages, and discolored and foul-smelling water. In 2020, TCEQ issued a default order against Seng Phet Souimaniphanh, doing business as TL Water Jones Acres, finding 32 violations of TCEQ rules and requiring corrective actions. On April 1st, 2022, TCEQ referred Mr. Souimaniphanh to the Office of the Attorney General for civil enforcement on his noncompliance with the default order. That referral eventually resulted in the 98th District Court of Travis County issuing a final default judgment and permanent injunction against Mr. Souimaniphanh in July of 2023. No actions were taken by the respondents to bring the utility into compliance with either the TCEQ default order or the District Court's default judgment. This long-term neglect for the utility and its customers and the noncompliance with orders of both the Commission and the District Court led the ED to determine that the utility had been abandoned and that the appointment of a temporary manager was necessary. The first emergency order appointing Aqua Texas LLC as temporary manager was issued on July 19th, 2024, and affirmed by the Commission on September 11th of 2024. During Aqua Texas's first term as temporary manager, they've made repairs to the system, and continuous and adequate service has been maintained. TCEQ has not received any additional complaints about the utility since Aqua Texas was appointed temporary manager. The order before you today renews Aqua Texas's appointment as temporary manager for an additional 360 days or for a reasonable time if Aqua Texas submits an application to the Public Utility Commission to acquire the utility's Certificate of Convenience and Necessity. During this renewed appointment, TCEQ staff will continue to work with the temporary manager to facilitate long-term stable service to the customers of the utility. The executive director respectfully requests that you affirm the July 16th, 2025 emergency order. I would also note one typographical error in the order. In finding of fact number 16, September 11th, 2023, should be September 11th, 2024. Thank you. We are available to answer any questions you may have, and I will reserve the remainder of my time.
Thank you, Ben.
Now we would hear from the respondents. Again, no one has signed in from the respondents, but if there's anyone here in the room, doesn't look like anyone is here. Again, no interested person signed in, and the temporary manager is also not here. So that brings us to OPIC.
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Director. My name is Elan Martinez. I'm Senior Attorney with the Office of Public Interest Counsel. For the record, we've reviewed the emergency order renewing the appointment of Aqua Texas Incorporated as the temporary manager of the TL Water Jones Acres utility and recommend that the Commission affirm the order. This utility serves approximately 40 connections and at least 25 people daily. Since 2018, it's been plagued by persistent issues, including the low water, outages, and discolored, foul-smelling water documented in 10 customer complaints that the Executive Director spoke of. These problems stem from the owners and operators' failure to comply with TCEQ regulations, resulting in potential health hazards and inadequate service. Further, the utility's history of noncompliance is extensive. A 2018 investigation led to a 2020 default order identifying 32 violations. A 2023 district court judgment and permanent injunction further confirmed these failures, yet the respondents have not communicated with the TCEQ or taken any steps to address these issues. This pattern of neglect constitutes abandonment under Texas Water Code 13.412F and 13.4132, justifying the need for a temporary manager. Aqua Texas was initially appointed as temporary manager on July 19, 2024, and its term expired on July 14, 2025. During this period, Aqua Texas has maintained minimum disinfectant residuals, conducted repairs, ensured continuous adequate service, and prevented potential health hazards. Their submission of an inventory of utility property and consistent monthly reporting to the Executive Director further demonstrate their commitment to transparency and accountability and in compliance with Texas Water Code 13.4132, which relates to temporary managers, and 291.43, which is the mirror language in our rules. Aqua Texas's operational expertise and willingness to continue serving make it well suited to maintain safe, reliable water service. Without their intervention, the utility's customers who have no alternative source of water would face significant risks. The Executive Director issued this emergency order on July 16, 2025, renewing Aqua Texas's appointment until July 11, 2026, or until a receiver is appointed. That order complies with Texas Water Code 5.501 relating to emergency orders, 5.507 relating to utility emergency orders, and 13.4132 relating to temporary managers, as well as 30 Texas Administrative Code 35.25, which relates to notice. It was properly served to the respondents via certified and first-class mail and by fixing copies to the utility's property. Affirming this order is critical to protect public health and ensure safe, reliable water service. Aqua Texas has proven its capability, and its continued management is necessary to maintain compliance and prevent further harm. So OPIC supports affirmation of the emergency order to safeguard the customers of TL Water Jones Acres. And I thank you. We're available for any questions.
Thank you.
The ED has a minute and 51 seconds for rebuttal if they wish to
need
use
to
it.
rebut.
I do not have anything to add. Thank you to the
Thank you.
Public Interest Council.
All right, colleagues, the Commission must consider whether to affirm, modify, or set aside the Executive Director's second emergency order, renewing the appointment of Aqua Texas as the temporary manager for the abandoned public water system. I believe the conditions for abandonment continue to exist with this system, and Aqua Texas continues to be a willing temporary manager. As such, I'd affirm the emergency order renewing the temporary manager for another 360 days. Bobby?
I agree. It's appropriate to move forward.
Also in agreement. Do I have a motion?
I move that we adopt the proposed order affirming the emergency order issued on July 16, 2025, as proposed today by the Executive Director, including the modification mentioned earlier.
Second. All those in favor say aye.
Aye.
The motion passes. Thank y'all very much. Let everyone shuffle, and we'll go to number 2, please.
While everybody is shuffling, I will note that the petitioner withdrew their petition yesterday, so no action is actually necessary on item 2. So we can actually move on to item 3. Item number 3 is the consideration of the application by Golden Triangle Polymers Company, LLC, for new Texas Pollutant Discharge Elimination System Permit number WQ00054320000. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning. Before us, we have an application for a new TPDES permit that would authorize disposal of processed wastewater, utility wastewater, and stormwater at a daily average flow not to exceed 5.14 million gallons per day in its final phase. The Commission received one hearing request and request for reconsideration from a Mr. Jonathan Webster. When considering hearing requests for these type applications, the Commission considers a two-step analysis. First, we must determine whether a hearing requester is an affected person. Second, if the Commission finds that a requestor is an affected person, we determine whether that person raises issues in their hearing requests that are referable to SOA. So I'll begin with my thoughts on affectedness. To be considered an affected person, a requester must explain how they will be affected by the application in a way that is not common to the members of the general public. The hearing requester must also file both timely comments and a hearing request that identifies their personal justiciable interests. Finally, the identified concerns must be within the Commission's jurisdiction to address in the authorization. Regarding Mr. Webster's hearing request, I agree with the ED and OPIC that he does not qualify as an affected person. In his hearing request, Mr. Webster did not explain how he would be adversely affected by the proposed facility in a manner not common to the members of the general public. Mr. Webster's hearing request indicates that he lives approximately 1,380 miles from the proposed facility in Outfall. Therefore, I believe that Mr. Webster is not identified a personal justiciable interest affected by the application. Accordingly, I would deny Mr. Webster's hearing request. I'll stop there and talk to my fellow commissioners. Bobby?
I also did not find Mr. Webster to be an affected party.
I agree.
As part of Mr. Webster's hearing request, he also requested that the Commission reconsider the issuance of the draft permit. He expressed general concerns regarding the anti-degradation review failing to account for cumulative impacts and climate-related ecological risks, inadequate community engagement, misalignment with the climate justice principles by further entrenchment of fossil fuel-based industrial infrastructure, and transparency of monitoring data. I do not believe that the RFR provides any additional information for the Commission to consider that was not already reviewed and considered by the ED, and I believe that the ED's RTC adequately addresses the concerns raised in the RFR. Accordingly, I would deny the RFR. Summing up, I would also deny the hearing request and request for reconsideration, adopt the ED's response to comment, and issue the permits. Bobby?
I agree.
I also agree.
Do I have a motion?
I move that we deny the hearing request and request for reconsideration filed by Jonathan Webster, issue the TPDES permit number WQ00054320000 to Golden Triangle Polymers Company, LLC, as recommended by the Executive Director, and that we adopt the Executive Director's response to comments.
Second.
All those in favor say aye.
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 Motion passes. Thank y'all. Appreciate you. We'll go on to item 4, please.
Item number 4 is the consideration of the application by Noises Green Ammonia LLC for new air quality permit number 174951. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record. As a courtesy to the legislature, the commission allows members of the legislature to make remarks or allow their staff to read remarks from the member at the agenda meeting, and I understand that Senator Juan Chuy Hinojosa has asked his staff to read his remarks to the commissioners, and that we have Ms. Suzanne Wilson here to address the commission. Oh, sorry, Suzanne. I'm very sorry. Oh, Susanna. I'll get it right. I'll get it right at some point. I'm very sorry.
Good morning. My name is Susanna Wilson, and I am sharing a letter from State Senator Juan Chuy Hinojosa, dated September 9th, 2025. Dear Chairwoman Pop, Commissioners Janeca and Gonzalez, please accept this letter expressing my continued opposition to Nueces Green Ammonia's LLC's Air Quality Permit Number 17495, which authorizes the construction of a green ammonia production plant in Nueces County. I appreciate the Commission's considering my previous letters and holding a public meeting in Robstown, where many of my constituents voiced their concerns about a proposed project and requested a contested case hearing. Ammonia is a highly hazardous substance, and exposure can lead to serious respiratory issues, irritation of the eyes, skin, and throat, and in severe cases can be life-threatening. Numerous residents of the Robstown and Northwest Corpus Christi communities have consistently raised concerns about its potential impact to air quality, public health, and the overall quality of life. I appreciate the work of the Office of Public Interest Counsel in carefully reviewing this matter and issuing a response to the application. I fully support OPIC's recommendation that the Commission refer this matter for a contested case hearing to the State Office of Administrative Hearings with a maximum duration of 180 days. Thank you for your time and consideration. Should you have any questions, please do not hesitate to contact my office. Sincerely, Juan Chuy Hinojosa. Thank you.
Thank you so much. Please tell your boss we said hi. Okay. All right, before us, we have an application for a new source review air permit to authorize construction of a new green ammonia production facility. The Commission received over 100 hearing requests and made a request for reconsideration. When considering hearing requests for these type of applications, the Commission considers the same two-step analysis I discussed in the last item. The Commission received timely hearing requests for one group and numerous individual requestors. I'll begin with my thoughts on effectiveness. To be considered an affected party, a requester must explain how they will be affected by the application in a way that is not common to members of the general public. The hearing requester must also file both timely comments and a hearing request that identify their personal interest and concerns that they have. Finally, the identified concerns must be within the Commission's jurisdiction to address in the authorization. For groups and associations, there are additional requirements for the Commission to review. For example, to be entitled to a hearing, a group or association must identify a group member that would have standing to request a hearing in their own right. Looking at the hearing requests submitted by concerned citizens of Robstown and Callan, I agree with the ED and OPIC that this group's hearing request should be granted. It filed timely comments and hearing requests which identified one or more members who I believe would have standing to request a hearing in their own right. The groups also meet the other requirements for a hearing, such as interests the groups have identified that are relevant to the group's mission, and their claims do not require the participation of their members to pursue. Turning to the individual hearing requesters in this matter, I agree with the ED and OPIC that the hearing requests of Myra Alanes, Samuel Alanes, Sandra Ariz-Mindy, Kelly Carrillo, Kimberly Castaneda, Michael Castaneda, Eileen Doetry, Brittany Donald, David Donald, Deborah Donald, Alvin Morin, Aracelia Morin, Yolanda Morin, and George Picha Jr. should be granted. I also agree with OPIC that we should grant the hearing request of Lawrence Firkin, taking into consideration the type and volume of proposed emissions, the issues that these individuals raised in their hearing requests, and their close proximity to the proposed facility. I believe that they have shown that they may be personally affected by this application in a manner that is not common to the general public. I would not find that Anita Contreras, Deanna Contreras, and Pablo Contreras are affected persons as recommended by the ED and OPIC because the issues they raised in their hearing request were not raised by them during the public comment period. I would also deny the remaining hearing requests, given that these requesters did not either file timely comments or did not identify a personal justiciable interest in their hearing request that would sufficiently differentiate them from the general public. I'll stop here and see where you land on effectiveness. Bobby?
You captured all the same parties that I did.
Also in agreement.
Let's move on to the second part of our analysis on issues. Affected persons raised relevant and material issues regarding health, animals and vegetation, cumulative impacts, air quality, nuisance conditions, best available control technology, monitoring requirements, and sufficiency and accuracy of the application. These issues are within our jurisdiction to consider for an air quality permit, so I would recommend that we send these issues to SOA. I would also recommend denying all requests for reconsideration because I don't believe they raise new relevant and material information for the commission to consider. And finally, I would recommend a 100-day hearing duration. Colleagues,
In agreement.
Same.
do I have a motion?
I move that we grant the hearing requests of concerned citizens of Robstown and Calallan, Myra Alanes, Samuel Alanes, Sandra Arizmendi, Kelly Carrillo, Kimberly Castaneda, Michael Castaneda, Eileen Doherty, Brittany Donald, David Donald, Deborah Donald, Lawrence Firkin, Alvin Morin, Arcelia Morin, Yolanda Morin, and George Picha Jr. I further move that we deny the remaining hearing requests and all requests for reconsideration. I move that we refer the matter to SOA for contested case hearing on the following issues: whether the draft permit will be protective of the health of requesters and their families, including sensitive subgroups; whether the draft permit will be protective of animals and vegetation; whether the draft permit adequately considers cumulative impacts; whether the draft permit will be protective of air quality; whether the draft permit will be adequate to protect against nuisance conditions from air contaminants affecting requesters' properties; whether the draft permit requires adequate emission control technology, including applicable BACT; whether the permit application contains accurate and complete emissions estimates and air dispersion modeling; whether the draft permit contains adequate monitoring requirements to demonstrate compliance with its terms, and whether the application contains sufficient and accurate information for TCEQ to develop a draft permit. And I finally move that we specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
Second.
All those in favor say aye.
Aye.
Motion passes. Thank you. Thank y'all very much. We'll hop to item number 5, please.
Okay, item number 5 is the consideration for adoption of the renewal with amendment of TPDES General Permit number TXG640000. The Executive Director's staff is here to present the item, and then I'll remind you to make sure the mic is really close. Thanks.
Thank you. Can you hear me? Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Shannon Gibson with the Water Quality Division. With me today...
Shannon, would you speak up just a little bit more?
Yes, apologies. I'm a soft talker.
That's all right.
With me today is Maricela Zartucci with the Environmental Law Division. Staff requests adoption of the renewal with amendment of Texas Pollutant Discharge Elimination System Conventional Water Treatment General Permit number TXG640000, which authorizes the discharge of wastewater generated as a result of conventional water treatment at water treatment facilities into or adjacent to water in the state. The proposed permit will replace the general permit that expires on October 12, 2025. A public notice was published in the Houston Chronicle on March 7, 2025. A hybrid virtual and in-person public meeting was held at TCEQ on October 7, 2025. The meeting was attended by 5 stakeholders, 2 attended in person and 3 virtually. The public comment period closed on April 7, 2025. The public notice was republished in the Texas Register on April 25th, 2025, as a result of a publication error, and a second hybrid virtual and in-person public meeting was held at TCQ on May 21st, 2025, in order to ensure adequate public notice had been provided. No stakeholders attended the second public meeting, and the public comment period reclosed on May 27th, 2025. Timely public comments were received from the Harris County Pollution Control Services regarding the meaning of the discharge adjacent to water in the state, and notice of intent requirements, effluent limitations, and monitoring frequencies for disposal via land application activities. A response to public comments document was prepared and included in your backup materials. No changes were made to the draft permit in response to public comments received. Staff recommends adoption of this general permit in response to public comments document. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you, and we're available for any questions.
Thank you, Shannon. Any questions for the ED?
I have none.
Mary, has anyone signed in on this item?
No one has signed in on this one.
Garrett?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. For the record, I'm Pranjal Mehta on behalf of OPIC. Our office has reviewed the renewal with amendment of the TPDES general permit. This permit authorizes the discharge of wastewater from conventional water treatment facilities into or adjacent to water in the state. This amendment includes important provisions such as a new requirement that discharges using chlorination for disinfection must be dechlorinated to less than 0.1 milligrams per liter of total chlorine residual before discharge. We also reviewed the public comments and the ED's responses. The EPA has reviewed and approved the draft without requiring any changes. Accordingly, OPIC supports adoption of this general permit. Thank you.
Thank you very much. Colleagues, I'd like to thank staff for their work on this item. The current permit will be expiring next month. The renewal with amendment makes some clarifying and conforming changes that are appropriate. It additionally includes new requirements regarding total chlorine residual, including effluent limitations and monitoring requirements. These changes should improve and clarify the permit, and I'm ready to move forward with adoption. I also believe that the ED adequately responded to comments submitted during the comment period, and I would support the adoption of the ED's response to comments. Bobby?
Thank you very much. I agree. I always want to take every opportunity we have to applaud the unsung hero of our agency of the general permits. Those standard permits give us a lot of certainty to the needs of industry in our state. And I think it's an important tool that can solve needs. I look at the range of fees. It goes up to over 15 million gallons a day and gives a clear pathway to our communities to get water treatment in a very direct, expeditious course. I think it's really important to continue to have these come before us. I'm grateful for it. I think the several dozen entities taking advantage of it today will continue to find the value there. Ready to move forward.
Well said. Katarina?
Also ready to move forward.
Do I have a motion?
I move that we adopt the renewal with amendments of Texas Pollutant Discharge Elimination System General Permit number TXG 640000 as recommended by the Executive Director, that we adopt the Executive Director's response to comment, and that we issue the Executive Director's proposed resolution.
A second.
All those in favor say aye.
Aye.
The motion passes. Thank you. Move on to items 6 through 9.
Items 6 through 9 are the consideration of the FY 2026 proposed assessment for annual costs for water master operations in the Rio Grande Water Division, the South Texas Water Division, the Concho River Water Master Program, and the Brazos Water Master Program. And the Executive Director's staff is here to present the item. I'll just remind you to keep the mic close to your face. Thank you.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Jose Davila Pepe, Section Manager with the Water Availability Division. With me today are Ruth Takira with the Environmental Law Division and Molly Mahler with the Water Availability Division. We are here to request the approval of the fiscal year 2026 assessments for the 4 Water Master programs, that is Rio Grande, South Texas, Concho, and Brazos. Notice of the proposed assessments was provided to all water holders in June. Water holders were encouraged to attend and participate in the July Water Master Advisory Committee meetings. At those meetings, assessment budgets were presented and feedback from the committees was considered. All 4 Water Master Advisory Committees voted to recommend approval of the assessment budgets before you today. And thank you, and we're available to answer any questions you may have.
Thank you very much. Any questions for Pepe?
No, thank you.
Do we have anyone signed up on this item?
No one is signed.
All right.
No one is signed in on these items.
Garrett?
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. For items 6 through 9, OPIC supports approval of the Rio Grande, South Texas, Concho River, and Brazos Water Master budgets for fiscal year 2026 and issuance of the proposed orders assessing the annual costs of these Water Master programs.
Thank you, Garrett. I greatly appreciate the work of our staff, the work of the Water Master Advisory Committees, and their recommended approval of the budgets. The budgets and assessments look appropriate, and I support moving forward with their approval. Bobby?
I'm so sorry. May I back up? I have a question for ED staff.
Oh, go for it.
Pepe, sorry to ambush y'all with this, but do you feel that staff face increased workloads in any way as water demands increase in terms of either drought or increased user demand?
We have responded to those challenges, and right now we're fully staffed, and we believe our workload is being met.
I really appreciate that. Am I incorrect in my understanding that while we've got adequate staff, it may feel like there's more work, more requests as we have enough water, things are always busy, but when we don't have enough water, it seems like things are really busy. Is that incorrect? An incorrect understanding?
We believe that situations change with water availability, but throughout the year, the existing conditions, the workload, triggers the workload to be consistent, and it not the fact that there's not water shortages in some areas doesn't necessarily mean that our workload is diminished.
I appreciate that. I think Mr. Davila is being very deliberate and thoughtful and recognizes that our agency always rises to the challenge. I think he also helps underscore my concern, whereas the budget and the check-in from the Water Master Program adequately captures our needs. Largely, I think there is an intangible piece that our staff still feel and that our water users still feel, and as we see ourselves in high demand from either drought or an increase of new Texans coming in to some of the parts of our state. I think we've seen the real value from Water Master staff in those areas, but I would put forward that the work challenges and problems become orders of magnitude worse in those we need water years. Just want to recognize that, and don't know how we can quantify or account for it, or even ask the ratepayers to try to increase what they pay for that very scarce, precious resource. I don't think it would be appropriate to, but I want to just acknowledge and recognize that I think that's a real demand that falls on our staff and on this touch point with the public. So I appreciate appreciate their work on it.
Thank you. And just to clarify, you all believe that these budgets are adequate and provide the resources you need to fulfill your mission?
That is correct.
Okay, that's all I need to know. Thank you. Katerina, do you have anything? All right, I move we approve the Rio Grande, South Texas, Concho, and Brazos Water Masters budget for fiscal year 2026 and issue the executive directors for proposed orders assessing the annual costs of those water master programs.
I second.
All those in favor say aye.
Aye.
Motion passes. Thank y'all.
Item number 10 is the consideration of the executive director's findings and recommendation on whether a water master should be appointed for the Canadian and Red River basins. And the executive director's staff is here to present this item.
Good morning again, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Jose Davila Pepe, Section Manager with the Water Availability Division. With me today are Ryan Rakowitz with the Environmental Law Division and Molly Mahler with the Water Availability Division. The Executive Director is required by statute to evaluate each river basin that does not have a water master program at least every 5 years to determine whether a water master should be appointed. During fiscal year 2025, we evaluated the Canadian and Red River basins. That evaluation included opportunity for public involvement, and the public comments received are summarized in the evaluation documents filed to support this agenda item. Copies of the written public comments received are also included in the filing. Our evaluation found no court orders, petitions to create a water master, nor repeated history of threatened water rights from 2020 to 2024. The Executive Director recommends that the Commission not move forward on its own motion to create a water master program for the Canadian and Red River basins currently. Thank you, and we're available to answer any questions you may have.
Thank you, Pepe. Any questions for ED staff? Has anyone signed up on this item, Mary?
No one has signed in.
Garrett?
OPIC appreciates staff's thorough evaluation and report of their findings and recommendations, and we concur with their conclusion.
I'd like to thank staff for your work on this. I agree that there's no reason to appoint a water master for these basins and support their recommendation. Colleagues?
I'm in support as well. I can't help but wonder, having seen a few of these from this perspective now, I wonder whether the legislature and the state might find value in dialing down the frequency of check-in or the mechanism of check-in, because it's a useful look, but one that seems to send a very obvious signal from this vantage point, acknowledging that 25 water rights holders always had the ability to initiate that question. Perhaps in place of a regular obligation, we would see value in having a smaller number, a few number of water rights holders could initiate a review of from our agency by request if it hasn't been done in so many years, the last several. But I appreciate the deliberative policy look into it and acknowledge the coming pressure point. This may be a really valuable exercise that we're engaging in, as that Texas miracle takes the growth of our state over some of the more delicate watersheds.
Katerina? Since it appears we're all on the same page that the water master isn't necessary, no further action is needed on this item. So we will move to item 11. Thank y'all very much.
Thank you.
Item 11 is the consideration of gifts and donations of $500 or more in value given to the TCEQ and submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning the acceptance of gifts and donations. The Executive Director's staff is here to present the item. I'll remind you about your microphone again. Thanks.
Good morning, Chairwoman, General Counsel, and Public Interest Counsel. For the record, my name is Yen Tran of the General Law Division representing the Executive Director. Before you are the gifts and donations the agency has received in the past 90 days in accordance with Chapter 575 of the Government Code. The Executive Director has accepted these gifts and respectfully request your acknowledgement of these items. I'm available to answer any questions you may have regarding these items.
Thank you, Yin. Any questions for the Executive Director's staff? Nope. Has anyone signed in on this item, Mary?
No one has signed in.
Garrett?
OPIC supports approval of the resolution acknowledging acceptance of gifts and donations as presented by ED staff.
Wonderful, thank you. I'd like to thank staff for assembling this information and thank all those who made those donations to this agency. I'm ready to move forward with approving the resolution that acknowledges acceptance of the gifts. Colleagues?
I move that we approve issuance of a resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCQ Interoffice Memorandum to the Commissioners filed in docket number 2025-0933-MIS.
A second.
All those in favor say aye.
Aye.
Aye. The motion passes. Thank you. All right. Item 12, please.
Item number 12 is the consideration of material changes to contracts for goods and services awarded under Chapter 2155 of the Texas Government Code, executed between September 1st, 2023 through August 31st, 2024. I think I may have those dates incorrect. So, no, are those correct? Okay, I just want to make sure. Thank you. The Executive Director's staff is here to present this item, and I'll remind you about your microphone, keeping it close by. Thanks.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yvette Owens, Contracts Work Lead of the Financial Administration Division. I have with me Chris Gobert, Procurements and Contracts Manager of the Financial Administration Division. We are representing the Executive Director. This item contains the material changes made to contracts for goods and services between September 1, 2023 through August 31, 2024. Reported material changes include extensions of the contract or completion of work for 6 months or more, or an increase in consideration of 10% or more, in accordance with Section 2155.088 of the Government Code. The Executive Director presents these items for your consideration, and I'm available to answer any questions you may have.
Thank you. Any questions for the Executive Director staff? Nope. Mary, has anyone signed it on this item?
No one has signed in on this one.
Garrett?
OPIC supports approval and issuance of the proposed resolution that acknowledges material changes to contracts for goods and services.
Thank you, Garrett. Again, I'd like to thank staff for their work on assembling this information. I've reviewed the changes and don't have any questions. Ready to move forward with approving the resolution acknowledging these changes. Colleagues?
Likewise.
I move that we approve issuance of the Executive Director's proposed resolution acknowledging the material changes to contracts for goods and services as described in the TCEQ Interoffice Memorandum to the Commissioners and Executive Director dated September 10, 2025, and docket number 2025-1112-MIS.
Second.
All those in favor say aye.
Aye.
Aye. The motion passes. Thank you. Let's move on to our enforcement docket.
Okay, well, that takes us to the enforcement docket, items 13 through 27 and 29 through 38. Item 28 was previously remanded to the Executive Director. The Executive Director's staff is here to present the item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 13 through 27 and 29 through 38. The total assessed administrative penalties are $2,879,264, with $518,339 deferred, $1,119,413 applied towards supplemental environmental projects, and $1,241,512 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Megan. Any questions for ED staff? Has anyone signed in on these items, Mary?
Yes, so first I'll note those who have signed in and are available for questions. We have individuals signed in for 13, 15, 21, and 30, and they will be noted for the record. On item 13 and item 24, we have individuals who have signed in and asked to address the commission. So we'll begin with 13, and we have Ms. Catherine Guerra.
Hi, good morning, Commissioners. Can you hear me?
We can, Catherine.
Hi, I'm Catherine Guerra with Public Citizens Texas Office. Public Citizen is a nonprofit consumer advocacy organization that champions the public interest in halls of power. This enforcement case against INEOS caught my attention because of the significant $2.2 million penalty. I think this may be the largest fine that we've seen from the agency all year, and we just want to commend agency staff for bringing a comprehensive enforcement case against this facility. But I do have significant concerns about the agency proposed agreed order and the penalty policies that are applied. This case is really interesting, and the more I reviewed it, the more those concerns grew, and so I hope that you share some of those concerns. The violations in this enforcement action date back to 2016, and yet the agency is proposing a $450,000 expedited settlement for this polluter. The TCEQ's website describes the enforcement process as where possible, TCEQ encourages expeditious settlement of enforcement actions by extending the agreed order. And if the settlement does not occur within a short time, the agency will start the process of an administrative hearing, but clearly that did not happen here. I don't know a reasonable person who believes that 9 years is a short time to negotiate a settlement with an industrial polluter. And I'm curious why a default order was not issued or why the case was not referred to the Attorney General for Civil Enforcement. In those 9 years, INEOS has demonstrated consistent pattern of noncompliance and has racked up an impressive 6 additional pending active pending enforcement cases just at this facility. INEOS already has 15 signed agreed orders at this facility since 2010. 22 enforcement cases against the same operator and the same facility, and the TCEQ has still met them with what appears to be leniency. We're seeing the same violations over and over. Failure to prevent unauthorized emissions, and yet every time the agency grants them a large deferral of the penalty. And the agency has not, to my knowledge, ever exercised its legal right to demand payment from INEOS of any deferred penalty amount for failure to comply with a previous agreed order's terms and conditions. INEOS even has another enforcement case, item 20, on your docket today for Galveston County facility. There's another on your upcoming September 24th agenda in Jefferson County. You know, despite all of this, TCEQ is still considering INEOS to be a satisfactory performer in their compliance history rating, and INEOS has applied for renewal or revision of its federal operating permit and its NSR permit number 95, which is linked to the vast majority of the air violations against them. These enforcement actions today are a really good step towards accountability, but if the TCEQ keeps doing business as usual and issuing these discounts, polluters are going to keep doing business as usual and make compliance a low priority or the cost of doing business. An expedited settlement deferral in this instance is wholly inappropriate, and you all have the ability to send a clear message to these repeat violators that tie up staff time and consume agency resources. And only with your leadership can we change how the agency awards massive polluter discounts and give teeth to these enforcement policies. And then you have the added benefit of building trust within communities. Thank you so much. And Chairwoman, if I could just on a personal note say, My former boss at the TCEQ, Deputy Director of Program Support and Environmental Assistance, Andrew Gardner, retired from the agency recently after 25 years. He was the best of the best at the TCEQ, and we wish him well in his next adventures, which I think involve a lot of fishing. So congrats to him.
Thank you. That's very kind of you. I will say, with all due respect, I do take issue with the business as usual comment. I think that our TCEQ staff analyze and work tirelessly to ensure that the public health of the state of Texas is protected. Amy, can you speak to the timeline on number 13, please?
Yes. Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. For the record, my name is Amy Sotomayor. I'm with the Enforcement Division. Certainly appreciate the comments today. This order is actually a result of a historical practice that the division used to engage with respondents in, where we combined multiple years into rather large cases. That practice did stop in 2023, but what happened then is we had to manage these cases and address these cases. We started actively developing this order in 2023, unfortunately, much after the deadline of the case investigations we'd received. And we provided the initial order to the respondent in May of 2024. We then engaged in over a year-long process with the respondent to make sure that the order that's presented to you guys today accurately reflects all of the compliance actions that the entity and the facility itself has taken to come into compliance with all of the violations in the order. As you would expect, that took some time. With over 20 investigations, close to 100 violations, that was a lot to comb through for our ECs and multiple layers of staff. We do believe that we've got a very solid order in front of you that appropriately addresses the issues at this site. I do want to note, we do have additional cases that will be coming forward, but the magnitude of the violations we're seeing at this facility are dropping. We're not seeing the same volume at this particular facility.
I think that's an important thing to note.
Yeah.
Absolutely.
And I do, just for the record, want to note that because we are trying to dig out of our backlog, and this was a historical practice for quite some years, we do have a handful of cases for other respondents that are going to be similar in size and similar in the time period that we're looking at here. And we're working through this as quickly as possible, but they are very complex, and it's taking us some time to get through those with the respondents that are affected.
Thank you, Amy. It was very helpful. Does anyone have questions for the ED staff?
I'll ask one clarifying question. I did want to note, I think we had one other requester, public requester we're still going to get to.
Yes, for a different
public
item.
comment on a different item. So good, understood. I want to zero in, and I think you mentioned it, on focusing in on that conversation of about approximate year period that we were discussing, that draft order with the respondent here, taking account of all of their actions towards compliance. That's what, as I understand it, largely drives the reductions for good faith efforts to comply, or what the commenter referred to more as an expedited action by the respondent. And I think that it is important to recognize that those amounts, those dollar amount reductions, probably are significantly large when you're talking about a consolidated number of different violations that can, cumulatively come up to over $2 million. So it is a complex piece, but I'm seeing from your head nod, you're confirming my understanding, and I'll offer you a chance to say something about compliance and what gets acknowledged.
Yes, so if they are able to demonstrate compliance with violations, we do apply a reduction in penalty for those, for good faith effort, and it depends on when the compliance is provided to us. And so any of the violations that we agreed that showed corrective action, we did apply good faith effort. And so I think in total of the 90-ish violations that we had, we were able to recognize compliance on close to 60 of those. The remaining violations are tied to that permit amendment, and we expect compliance on those very soon.
Katarina, any questions? Nope. Do we have another
We have Mr. Javier Ramirez signed in on item 24, and he's virtual. Oh, I'm getting a message that he is actually not online. So I think that exhausts those who have signed in to address.
Okay. Garrett?
OPIC has reviewed each of these enforcement items, and except for remanded item 28, we support adoption of all the orders presented by ED staff.
Thanks, Garrett.
Can I have just one moment? I'm sorry. I need to ask Mary something.
Sure. Yes, we will take a 5-minute recess. Come back at 10:40.
Thank you. Apologies.
This meeting is back in session. Where were we?
I think in discussing the enforcement docket, I'm happy to move forward on that docket. I will close out the discussion and just respond back to the comment from Ms. Guerra. I appreciate your thoughts, Chairwoman. I want to express my appreciation to Ms. Guerra for the thoughtfulness to dig in and peek into the details of these matters. I think, as you heard from our staff, they are lengthy, complicated, but important discussions. And I think that feedback from your organization, feedback from members of the public, when they see and understand and take the time to offer their response to that, that is something that is helpful feedback. And it's meaningful to us, if not in the moment, if not on that exact order, at least in informing us to where we need to try to direct the conversation with respondents in future matters. So just wanted to acknowledge and give a little positive note towards the comment. Thank you.
Thank you, Bobby. Appreciate that.
Before we move on, we received a late registration for somebody to speak on item 21. Errol Summerlin, he's virtual.
Mr. Summerlin.
Yes, Commissioners, can y'all hear me?
Sure can.
Thank you very much for the opportunity. Commissioners, my name is Errol Sumlin, and I'm now a resident of Salisbury, Maryland. I'm here to speak on item 21. I was living in Portland, Texas when CCL got their original permit, and I watched as they began flaring what we affectionately now call the Eye of Sauron in 2017. A flare that has annoyed and angered residents for 8 years now. I realize you're somewhat constrained from imposing significant fines and penalties for violations of air quality standards and special conditions imposed on air permits, but you do have some discretion. In this case, you impose a penalty of $34,800, with half of those funds going to Trent Thigpen's auto emissions program, checking to see if the emissions from our automobiles pass muster. It's a great program. I had my cars checked for free and they passed. If they hadn't passed, funds from the project would help pay for repairs. But $34,500 can be offset by CCL's profits in the blink of an eye. The violations occurred over 2 years ago, and the record shows CCL did not achieve compliance until December 9, 2024. What was the estimated cost to CCL to comply? $10,000. You have the discretion to enhance the base penalty on factors such as compliance history, culpability, and good faith effort to comply. You found no culpability even though the incident began in March 2023 and lasted almost 4 months. You enhanced the penalty by a mere 26% for failure to comply, and then gave them a $3,000 credit for a good faith effort to comply. That's just not right. A $10,000 fix should have been corrected in 2023. The penalty assessed here is woefully inadequate. It's no surprise that CCL would enter into such an agreed order. Now, I know not to expect a change at this stage of the game, but in the future, we hope staff will use their discretion to enhance these penalties when warranted. In the instant case, CCL's case, a lot of folks in the coastal bend believe it was significantly warranted. Thank you so much for your time today.
Thank you, Mr. Summerlin, for your thoughtful comments. I'm ready to move forward. Do I have a motion?
I move that we adopt items 13 through 27 and 29 through 38 as recommended today by the Executive Director.
Second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank y'all very much. Move on to item 39.
Good morning.
Commissioners.
Oh, let me call the caption.
Oh,
Sorry.
sorry.
No worries. Item 39 is the consideration for adoption of the proposed Collin County second 10-year maintenance plan, SIP revision for the 2008 lead NACS. And the executive director's staff is here to present the item.
Good morning. Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Eugenia Reynoso with the Air Quality Division. With me today are Allison Stokes with the Air Quality Division and Amy Browning with the Environmental Law Division. For your consideration today is item 39, the Executive Director's recommended revision to the State Implementation Plan, or SIP, to provide a second 10-year maintenance plan that ensures the Collin County area remains in attainment of the 2008 lead National Ambient Air Quality Standard through 2037, as required by Section 175A, subsection B of the Federal Clean Air Act. Staff respectfully requests adoption of the SIP revision. Thank you for your consideration, and we're available to answer any questions.
Any questions for ED staff? Mary, has anyone signed in on this item?
No one is signed in.
Garrett?
Good morning again, Chairwoman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez with the Office of Public Interest Counsel. For the record, we've reviewed the Collin County 10-year maintenance plan, state implementation plan revision for the 2008 lead NACS and support its adoption. This SIP revision fulfills the requirements of Federal Clean Air Act, Section 175A sub B, providing an updated maintenance plan to ensure the Collin County area, previously designated non-attainment around the Exide Technologies facility in Frisco, remains in attainment of the 0.15 micrograms per cubic meter lead standard through 2037. The area's history underscores the need for this plan. EPA revised the lead NACS in 2008, designating the Exide area non-attainment in 2010. Exide permanently shut down operations in 2012 with decontamination and demolition completed by 2013, leading to attainment by 2015 and redesignation in 2017 with the first maintenance plan. Since then, lead emissions have been zero, as confirmed by the emissions inventory, and future projections through 2037 show no resurgence, thanks to the facility's closure and voided permits. Any new lead-emitting operations would require new source review, which could ensures ongoing protection. The plan includes a robust maintenance demonstration, continued ambient air monitoring at 2 sites in the Frisco Eubanks and Frisco Stonebrook areas in compliance with 40 CFR Part 58, and a contingency plan with warning and action level triggers at 90 and 95% of the standard, respectively, to prompt swift corrective measures if needed. No new control strategies are required, imposing no additional impacts on the regulated community, while the public benefits from sustained air quality improvements. The public comment period ran from April 7th to May 12th, 2025, but we received no comments, and the virtual hearing on May 9th likewise generated no comments. This indicates both that there were appropriate measures taken to involve the public, but also that there is broad acceptance of the SIP. There are no significant changes from the proposal and no controversial concerns. Adopting this SIP revision by September 10th will allow timely submission to EPA by September 27th, 2025, avoiding potential sanctions or federal implementation plan. It safeguards public health, maintains environmental progress, and aligns with TCQ's commitment to clean air. OPIC therefore supports its adoption, and we're available for any questions.
Thank you very much. I'd like to thank staff for their work on this second 10-year maintenance plan for the lead NACS in Collin County. This second 10-year plan should be the last step in demonstrating Collin County's attainment, which is very exciting, and I'm prepared to move forward with it. Colleagues?
I agree.
Do I have a motion?
Just 1 second. I just wanted to thank the staff as well on this. I know that these are, they take a long time, and just sort of highlights the importance of staying in attainment, because, you know, once you're designated, once you get back into attainment, you still have these 2 10-year plans, so then you're still subject to EPA oversight for 20 years. And that's significant. So I'm glad to see the progress here, and glad that we're on our second 10-year maintenance. But so I move that we adopt the proposed Collin County second 10-year maintenance plan, state implementation plan revision for the 2008 lead National Ambient Air Quality Standard as recommended by the Executive Director.
I second.
All those in favor say aye.
Aye.
Aye. The motion passes. It was well said.
Okay, well, that brings us to our public comment session. The commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except the commission cannot receive comments on pending permit matters or other contested cases because these are subject to a prohibition found in Texas Government Code Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with a total time for public comment limited to 1 hour. Please note that the commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response and the recitation of existing policy. And with that, I'll begin with the first person on my list, who is Elizabeth Lieberknecht, and she's in person.
Good morning.
Good morning, Elizabeth. It's nice to see you.
Nice to see you. Can you hear me all right?
You can.
Good morning, Chairwoman Pop, Commissioners, General Counsel, and Public Interest Counsel. My name is Elizabeth Lieberknecht, and I'm with the Environmental Defense Fund. Today, on behalf of EDF and our coalition partners, I am delivering a letter enclosing the signatures of nearly 2,000 Texans who urge the Commission and the Executive Director to continue the critical work to implement performance standards for methane emissions from the oil and gas industry in Texas. Methane is a powerful greenhouse gas with over 80 times the warming power of carbon dioxide in its first 20 years in the atmosphere. But it is also emitted alongside harmful air pollution like poisonous hydrogen sulfide and volatile organic compounds, some of which are carcinogenic in addition to smog forming. Methane is the primary component of natural gas, so cutting methane pollution will reduce energy waste in Texas's oil and gas sector, benefiting operators, communities, and the taxpayers. No state has more to gain from implementing the 2024 EPA methane rule than Texas, the country's largest oil and gas producer and polluter. Significantly reducing oil and gas emissions will improve air quality and reduce health risks because the industry is responsible for a sizable share of the state's area VOC emissions, including in the 3 major producing basins, the Permian Basin, the Eagle Ford, and the Barnett Shale. VOCs are regulated as a precursor to ozone or smog, which can worsen respiratory illness, lead to heart disease, and cause premature death. Ozone pollution is particularly harmful for vulnerable populations such as school-aged children, people with respiratory illness, older adults, and people who are active outdoors, especially outdoor workers. Air pollution from oil and gas production contributes to thousands of early deaths and childhood asthma cases nationwide, totaling $77 billion in annual health costs. The wasteful and polluting practice of flaring also impacts our health and welfare. In Texas, in 2016, Texas led the country with the number of deaths and asthma incidents that can be attributed to the air pollution from flaring. But methane mitigation is more than sound environmental policy. It's also sustainable economic strategy. Every year, Texas operators waste billions of dollars in natural gas through leaks, venting, and flaring. In 2023 alone, that waste equaled 590 billion cubic feet, enough gas to meet the household needs of 14 million Texan households. Methane mitigation is a fast-growing and innovative industry, creating tens of thousands of good Texas jobs in leak detection, repair, and driving billions of investment in cleaner energy infrastructure across the state. Texans are already feeling the impacts and bearing the costs of the changing climate, including worsening drought, extreme heat, and catastrophic storms and flooding. Science shows that reducing methane pollution now is the fastest way to slow this warming. We recognize and deeply appreciate the time, energy, and effort staff have already invested in developing a state plan to regulate methane emissions from existing sources. While EPA recently took action to extend the state plan deadline until just January 2027, we encourage the agency to keep up its momentum. That's time.
May I briefly conclude? Thank you.
Specifically, we request that TCEQ continue with state implementation efforts, including by providing regular updates to the stakeholders on the rulemaking, including specifically updating the agency's Quad OC webpage with an updated timeline, and leveraging the additional 10 months of state planning time by publishing a discussion draft of a working state plan ahead of Texas Register publication, and providing additional public engagement opportunities like an extended notice and comment period during formal rulemaking. Texans are counting on TCEQ to move forward with these important regulatory protections, which will improve our air quality, protect our health, and ensure that our state's natural resources are developed responsibly, building and sustaining a more resilient Texas. Thank you for your attention and consideration today, and thank you to the dedicated staff working across the agency to reduce this harmful pollution. For any follow-ups about our letter or our coalition, please feel free to reach out to me. Thank you.
Thank you, Elizabeth. Appreciate it.
Thank you.
Next, we have Errol Summerlin, who is virtual.
Morning, Commissioners. My name is Errol Summerlin, and I currently reside in Salisbury, Maryland, after 40 years in the Texas Coastal Bend. On numerous occasions, I have heard attorneys and industry folk openly state, if the TCEQ required it, we would do it. Back in 1968, I worked in the steel mills of Gary, Indiana. I was 16 years old. Steel mills covered 4,000 acres, stretched for 7 miles, and was a place where folks could make good money. I was there on a summer job. I, like the old timers, left the job each day with soot clinging to my clothes and skin and wanting to see daylight and fresh air. But on days with little wind and not a cloud in the sky, skies were gray. You could stare directly at the sun, and I swear you could see sunspots. I had a great time in Gary, though. Spent times on the beach of Lake Michigan, bought my mom a new portable dishwasher with the money I made. But for almost 80 years, these steel mills operate without emission controls because no one told them they couldn't. Ultimately, the EPA did set standards for the steel mills, with even stricter controls on the horizon when it was announced just on August 27 that those standards are being rolled back. Lee Zeldin, the administrator of the EPA, is quoted as saying, when you add up the dozens of different actions that we have announced and that we're working through in one agency in 1 year, we'll do more deregulation than entire federal governments have done across all agencies across entire presidencies. That's our EPA director. So now these big steel standards are being rolled back across the industrial spectrum from raw source to market. There are new delays in rulemaking on vital areas of importance, including adopting rules on methane emissions. From the Permian Basin to the exports arriving in world markets, methane travels the world. We know it's in the natural world around us, but industrial emissions are upending the balance of nature. The EPA has now slowed the development of regulations that would reel in the methane emitted across the state of Texas. Methane that presents a danger to public health and our global environment. Unlike the soot in Gary, methane doesn't turn our Texas skies gray, nor can they simply wash it off. Our failure to control it would be a generational mistake. I ask you to move forward with the promulgation of rules regulating and controlling emissions of methane at all point sources in the chain of production. Don't wait for the EPA to take action. Industry will do what's right if and when you tell them to. As they say, if the TCEQ required it, we'll do it. So I thank you very much for your time and all the work of staff on this issue. Have a great day.
Thank you, Mr. Summerlin. I hope you have a great day as well.
And our final individual signed in is Kathy Fulton, also virtual.
Ms. Fulton?
Yes, good morning. Can you hear me okay?
Good morning. We can hear you.
Great, thank you. Been a few months since I have been spoken, and I do want to say real quick on item 21, $34,000 to Chenier. What? I bet they were laughing at that nothing penalty.
Fulton, we need to confine the comments to general policy matter. We can't be talking about enforcement cases or previous docket items.
What I do want to talk about though is I own a house in Fort Davis, Texas also, and I've recently had a problem with someone in the quote neighborhood dumping, well, actually making a huge trash pile on their property that's within a certain distance of the public right of way. Actually, it's in a neighborhood. And what was interesting is I found out, or at least it appears, if I've got my information correct, that under the Texas Health and Safety Code of 343, in chapter 343, specifically 343.011, this code applies to unincorporated areas of a county, such as, in Jeff Davis, pretty much most everything is not incorporated in that sense. And so I've talked to the sheriff's office out there, and we've kind of gone back and forth. But when I found this code, I actually found it through TCEQ's information and website. So I guess I'm interpreting that as TCEQ is actually an overseer of some of these things when it comes to debris and refuse that can create problems with water runoff into certain areas. Also, just refuge in general that creates problems with other nuisance pests and rodents and things of this nature. Not to mention that there's like, I don't know how many tires that are stored on this property. This trash pile though has just got everything. It's got like old asbestos in it. It's got, it's
I'm
huge.
sorry, but
It's
I
like,
think
well,
again, because you're going into a specific matter and a potential enforcement issue, we probably have to diverge back into a discussion of general policy or.
Well, I guess what my question is, Ms. Smith, is trying to understand who at TCEQ I can contact to motivate our local sheriff's office, because they didn't seem to fully understand how they were a little confused about how the code. I'm just trying to get some help with getting them a little bit better informed as a way to go about this. And I also want to say I wish TCEQ would, or if there's a way to kind of go out and educate people about things of this nature. When you've got a 14-foot tall pile of trash that is my viewpoint from my back porch, and I can't see the roof, the Fort Davis, the actual historic fort any longer. That's not the issue. What's the issue is all the stuff blowing off of it onto my property and everything that's in that pile. So I just would like some guidance here. I'm not sure who I talked to at TCEQ because I keep kind of getting a bit of a runaround. But I just want to make you all aware. Thank you.
No, Ms. Fulton, I understand. I would like to ask Garrett if he would have his office contact Ms. Fulton and see what the agency can do.
Yes, ma'am, can do.
Thank you. All right. Is anyone else signed in?
That is the end of our public commenters. So that brings us to items 41 through 44. The commission will be meeting in closed session today in room 4222 of Building F at, do you want to say 11:20? Give everybody 15 minutes? Yep. At approximately 11:20 is permitted by the Open Meetings Act, including Texas Government Code sections 551.071 and 074, to take up and consider matters pursuant to items numbered 41 through 44 as posted and noticed.
Thank you. This meeting stands in recess.
The commission met in room 4222 of Building F for closed session from 11:29 a.m. until 12:27 p.m. on item numbers 42 through 44 as posted and noticed. No action was taken. This agenda stands adjourned and the time is 12:40.